The Red Hat. Okay, the Red Hat. I noticed a name on the proceeding, and I believe it was yours. They're moving to arbitration in the Red Hat discrimination case. This is the case of a white Christian man who was fired. I don't know if he was fired for being Christian, but he was certainly fired for being
he checked all the wrong boxes. I mean, the main
white
reason they fired him
Christian male.
Yeah, the main reason was because he was male. But the other reasons, but it was even worse that he had no saving graces. It was okay to be it wasn't okay to be a man, but maybe you could save your job if you were a minority. Maybe you could save your job if you were a racial minority or a religious minority or if you weren't straight, So it's something to salvage your terrible toxic masculinity. But Red Hat, owned by IBM, found him particularly inexcusable because he checked all the wrong boxes, discriminated against him, ultimately fired him because of it, fired a whole bunch of people at the same time for the exact same reason. I've heard from other people who are like, that this is why I got fired. So IBM is one of the most discriminatory companies in the country, led by its subsidiary, Red Hat.
There was evidence of quotas in that context.
Oh,
right?
yeah. I mean, and they also made it explicit. This is the one James O'Keefe outed on tape, saying we're going to hire and fire people, promote or demote people based on their gender. That priority 1, priority 2 based on their race, priority 3 based on their religion, priority 4 based on their bedroom behavior. But number 1 was gender. They thought they didn't want a bunch of men, even though it was a field naturally occupied by men. It's always interesting. I don't see all the feminists demanding to take over high-rise construction. I don't see all the feminists demanding to take over fire departments. I don't see a bunch of feminists demanding to be on the front lines of military war and get drafted. I don't see a bunch of feminists demanding to go work in the coal mines. Overwhelmingly, the most dangerous work in America takes place by men. That's who does it. And those are the jobs that the feminists don't really want. They want the jobs they see as Kamala Harris kind of jobs, where you can be incompetent and still get a paycheck and still get a promotion. But this is what Red Hat and IBM became complicit in, and they don't want the world to know about it. So they're moving to compel arbitration. His employment agreement says nothing about arbitration. He didn't agree to arbitration in the employment agreement. So what they're doing, and this is a lot of corrupt employers. We talked about it recently. Disney's doing it.
Mm-hmm.
They're trying to find any time where they can contract with you over something small or modest that you're not going to read in full detail, and bury in it a mandatory arbitration clause that then magically applies to every disagreement you ever have with them. And so in a sales bonus package deal that was about a special marketing plan, had a little provision about arbitration, and they're saying, aha, this means nobody can ever sue us in America's courts. Nobody can ever get a trial by jury. No, the public can never know the truth about our illegal behavior, about our discriminatory animus, about how prejudiced and bigoted IBM and Red Hat are, because we get to go to a secretive star chamber-like proceeding with a conflicted arbitrator who's being paid by IBM to adjudicate the case without any rules of evidence being applicable, any rules of due process being applicable, any rules of appellate procedure being applicable, any opportunity for a jury trial being applicable, where we can charge you the privilege of being screwed so that your client has to write ridiculously huge checks to this corrupt arbitrator, conflicted arbitrator, who all the evidence proves rules overwhelmingly for corporations. This is a return to what led to the right to trial by jury in America in the first place, as Justice Gorsuch talked about just this past couple of months ago, as we discussed here, which was the British colonial administration didn't like American courts because American judges and American jurists were honoring their local community and the actual law. So they created their own special vice admiralty courts without the benefit of trial by jury, without the benefit of a person who was not conflicted by their appointment, and they were rigging the cases against people. And that's what arbitration has become. And arbitration is just one big railroad job that deprives us of our right to petition the courts for redress of grievances, the right to public, open, honest, transparent trials, the right to a decision maker appointed by elected officials, the right to full, meaningful appellate review, the right to due process of law in the entire discovery process, the right to confront accusers, the right to discover evidence, the right to evidence that's only been tested with the means of reliability for that evidence, the right to trial by jury, all of it gone with arbitration. And the courts have become complicit in supporting this arbitration because it helps the government and big corporations who they're basically in bed with. And Congress has passed laws that have been interpreted too loosely, too liberally, and too broadly to eviscerate constitutional rights they never had the privilege or power or prerogative to do in the first place. And since courts aren't going to, so I'm challenging every aspect of the arbitration in the case in Red Hat and going to litigate it all the way up in IBM. But and people can use and cut and paste however they want. No copyright asserted. You take authorship. I don't care. Use it for your case in the state and federal court. I'll be putting the whole brief up. Put it up as part of the Barnes brief this past Friday at vivabarneslaw.locals.com. Cut and paste however you want. Going to put up the whole brief this week at vivabarneslaw.locals.com. Cut and paste however you want. Because arbitration is a major threat to constitutional liberty in America.
One thing that you alleged in the brief, and I forget if it was the rebuttal to their motion to dismiss or motion to arbitrate, you said that Congress basically said you can't compel arbitration for discrimination lawsuits. How do you get around that?
So because the Supreme Court found, so two things. If the case concerns gender-based discrimination, harassment, Congress has made clear that those claims can't be arbitratable. So we should, on those grounds, win anyway. But you never know because judges have gone out of their way to find excuses to send cases to arbitration. And that's why we're litigating all the rest. That it violates when the Supreme Court greenlit this, they either the facts were very different or they just lied. Because they claimed, there's no difference between the arbitration process and American courtrooms, other than a jury. And that's not a big deal. It was completely false. But now it's proven false. There have been massive detailed studies. Arbitrators are in the pocket of the corporations they serve. That they rule you have a better chance at impartial justice in a tax court dealing with the IRS, which is the most notoriously biased court in America, than you do with an arbitrator. The corporations win at a 90% clip. Almost nobody is able to successfully challenge them. Corporations wouldn't do it unless they were guaranteed to get a better outcome with an arbitrator than with a jury, a better outcome with an arbitrator than a federal judge, who's already very sympathetic to corporations to begin with. That's how much these people are in the pocket. And so it's these secretive trials. Not only that, the public doesn't find out the truth. The public doesn't know what discrimination is taking place, what illegality is taking place by a company that has major government contracts at this local, state, and federal level. That's information they're entitled to. That's the point of open access to the courts. So the other thing arbitration is doing is keeping secret the illegal behavior of powerful people. And we should be opposed to it on core constitutional grounds.
It's funny. As a practicing attorney, I loved arbitration, not for any nefarious reasons. I hated the courts, and I figured it was the way of not bypassing, but getting out of the corrupt court system where you just spend all day waiting around not to be heard. And it cost more. It was quicker, confidential. But now I appreciate on the flip side, those might be good for some of the players, but not for justice as a whole.
And this is a case of mandatory arbitration. If people want to do true voluntary arbitration, that at the time of their dispute, they would have more confidence in an arbitrator, like some labor disputes that's true of. Then no problem. But that's not true with compulsory, coerced arbitration in take it or leave it standard form contracts where there's a huge negotiating power between the parties.
Yeah, the contracts of adhesion in terms of compelling arbitration on the player that doesn't have the bargaining power is exploitive.